Many immigrants whose deportation cases were closed many years ago think that they're safe from deportation. The truth is that your case is never truly closed until you have a final decision granting you legal status or removing you from the United States. Stick around for a couple of minutes and I'll explain to you what you need to watch out for to keep your family safe. Hello everyone, I'm attorney Lee Marvin and I have been practicing law for over 20 years with an emphasis in immigration law for the last 13 years. My main office is in Grand Rapids, Michigan, but I help individuals and families from any state in the country and really any country on the planet. I also have a 96% approval rate for immigration cases filed. So many of you heard by now the news that the current administration is reviving deportation cases that immigrants thought were closed many, many years ago. Most people don't realize that a case which is administratively closed doesn't mean that it's closed. It means that it's not currently scheduled for a hearing with a judge. The reality is that the case is still under the authority of the immigration court, and it can be revived or reopened at any time at the request of the government, the court, or the immigrant themselves. The difference is the fight that you thought you fought many years ago that's reopened, you've got to fight it again, and you probably have fewer options than what you had before. Who is specifically at risk for this sort of process happening? Okay, for the most part, those at risk are immigrants who requested administrative closure so that they could work with USCIS to move forward with a family-based petition. Because the court and USCIS have different authorities and different powers, and you can't move forward with USCIS if you have an active court case. So closing the court case allows you to move forward with USCIS. If that process wasn't successful before, or you are waiting for a visa to be available, then you are at risk of your deportation case being reopened again. So what makes this case or the situation even more difficult than just having to refight your deportation is that many people don't receive their notices anymore, or they don't receive it in a timely manner to go to court. This is because when the cases are closed, people end up moving, they relocate. If the notice was sent to them, it was sent to their old address, or it was sent to their attorney, and perhaps your attorney is no longer practicing law, has retired, the firm doesn't exist anymore, is practicing in another area of law, and never received your notice. If your case has been closed for a decade, which is very common, you have this added problem of actually receiving the notice. Because guess what? The court can still move forward with or without you. So if you don't show up, if you don't have a notice, you don't receive the notice, the court's not going to stop. They're going to move forward, and they will essentially order you removed from the United States, and you don't even know it until one day you're at a traffic light or something weird happens and you're picked up by ICE and you are immediately removed from the United States. Key takeaways. Court hearings will resume for many people. You must respond to any notices and show up at anything scheduled. Even if you think that your case was closed, you got to still show up. And remember that missing a case or court date does not stop the case. It just means that they will move forward without you, whether you participate or not. My recommendation for you is that before you receive that notice to appear in deportation court, if you are in a family relationship that allows you to move forward with the process, that you reach out for assistance right away. You can click the link below. You don't want to be caught off guard. You want to get ahead of this before you receive that notice, and hopefully you could maybe stop that notice from ever coming to you. So as always, stay informed, stay safe, and never give up on your immigration journey.